All right, Robert. The indictment heard round the world. Now, we didn't get I keep forgetting, like, we haven't done a show since that indictment, but I've talked about it a couple of times. Uh, Tell me why it's not the most absurd indictment you've ever seen. Did Alvin Bragg look like someone who was like a worm squirming on a hook? How does he say? I know people have said they technically don't have to specify the underlying crime in the indictment. When the reporter asked Alvin Bragg, what is the crime? What is the, what did he say corrupt means? Other crime. What is the crime that Trump was falsifying business records to hide? He alluded to the fact that it was federal election law. And my understanding is there's a big problem for a state to try and invoke a federal crime that has not been prosecuted and has actually decidedly not been prosecuted as the underlying crime for a state charge. But he seemed to have also suggested it would have been New York State election law as well. And my question is, how could New York State law apply to federal elections? But I maybe that's a dumb question. What's your overall take on this? I mean, I think I know it's going to be. Tell us how stupid this bloody indictment is.
Well, it is confession through projection because essentially the indictment puts into detail what Hillary Clinton did in 2016. So Hillary Clinton disguised to the FEC, disguised on all of her disclosures, payments to Perkins Co. as legal fees that, in fact, were not legal fees, that they were laundered money on behalf of Mark Elias and others to Christopher Steele and people who had retained Christopher Steele to spread Russiagate that led to real harm, that led to people being spied upon, including the president himself and his allies, that led to the derailment of a meaningful détente between the U.S. and Russia that has now precipitated a war in Ukraine that risked World War III on a global scale. So, that was real consequence, not just corruption of the election, corruption of American federal law enforcement, corruption of the national security state, corruption of the ability for the president to execute on his promises and from the election. All of it, because it's what led to Mueller. It's what led to all of it was this bogus dossier, which had been secretly funded by the Clinton campaign, but disguised all along and laundered as legal fees to Perkins Co. So that's the real crime. Of course, nobody in New York could find reasons to prosecute that.
Robert, Alvin Bragg said they have a long history of pursuing this type of paper crime, this white-collar crime.
No such history. He can't cite a single or an analogous case ever.
I had been going on.
Instead, he had to put it into a group category because there is no analogous example that he could identify, which was part of the issues at the press conference. Name the other instance where somebody was charged with falsifying business records in New York in order to cover up an alleged election finance disclosure issue. Doesn't exist. Never happened. And it's not like that incident, underlying fact pattern, has never happened. As we note, Hillary Clinton was in New York when she did this. So this was very specifically New York. But so the reason why he has not identified a crime is he wants to change his theories in case one of them gets struck down. So what you're not allowed to do is give such inadequate information to the defendant that they don't know how to defend themselves. And that's exactly what he's done here. That's a constitutional restraint. There's a procedural remedy called a bill of particulars that can be requested. But the constitutional principle behind it is that you as a defendant get to know what it is you're defending against. And the statement of facts that he had put up on his website that he's now taken down, Bragg, made it clear they're really going to switch gears if they need to. They're going to say, well, maybe it was to cover up Trump committing an election crime. But if that doesn't work, it was to cover up Cohen committing an election crime. But if that doesn't work, it was to cover up somehow some New York election crime. But if that doesn't work, it was to cover up Cohen not paying his taxes. But Cohen did pay the tax on that amount of money. That's what the payment was for. So the key aspect is in the misdemeanor law itself, it requires intent to defraud. Falsified business records by itself is not a crime. Now, the problem correlates to the federal issue that we'll talk about a little bit later before the U.S. Supreme Court, is there's a lot of prosecutors across the country at both the state and federal level, but using federal precedent to expand the definition of defrauding to basically include any form of inaccurate representation. And that's not what it's supposed to be. Somebody's supposed to have been hurt in property, their money or property stolen from them. And instead, they redefine this. They call it honest services obligations, or they say the right to control was interfered with. So, the right to honest information is an economic transaction. I mean, all this garbage that basically makes any alleged false representation a crime, when the whole point is we don't criminalize lies, we criminalize lies that hurt people. We limit it, and the reason is because we know the government, if they get to criminalize lies, will end up prosecuting people who they just think who just disagreed with them, and they want to call it a lie. So, but the intent to defraud provision, because that was the other question, is like only person victimized here was Trump himself. He had to pay off somebody who was extorting him, using the campaign to do so. Arguably, Cohen was part of the extortion himself by requiring he reimburse him because it's not clear what Trump knew when and where, and demanded that he pay his tax and everything else on it because he claimed to have done this for the benefit of Trump. And so who was defrauded? Cohen wasn't defrauded. He made more money than he deserved. Stormy Daniels wasn't defrauded. She got more money than she deserved. The state of New York wasn't defrauded. They got more money than they deserved. The U.S. government wasn't defrauded. They got more money than they deserved. So who was defrauded? So their theory of fraud is probably going to be some sort of honest election or some other garbage that would just basically give prosecutors the ability to prosecute anybody, anywhere, anytime, anything you say, anything the government disagrees with, and they can call misinformation and put you in prison for it. It's the same thing they're doing in January 6th. They're trying to use Trump's case to create the same perilous precedent, and every other state will pick up on it. It's an attempt to criminalize disinformation. It's an attempt to put people in prison for dissident speech. It's the reason why Julian Assange prosecution never should have been greenlit. Once you start making it a crime to do something the press does every day that exposes whistleblower information, then all of a sudden they're going to use it against everybody else. That's what this is really about in part. Part's about taking out Trump, but it's also about let's put our political opponents in prison and find new legal theories to do so using obstruction and fraud statutes as our means, because we've interpreted them so elastic and the Supreme Court has let them get away with this for too long that now it's become a immediate risk and threat to speech in America. These cases, think whatever you want about Trump or Trump and Stormy Daniels, this case is a direct threat to the constitutional liberty of every single American.
I want to highlight something that I said it like a number of times last week, and I forgot we haven't yet had our show on this, but just to highlight the difference or the similarities between Hillary Clinton. And it's not to say, look what she did, she wasn't prosecuted for it. What she did was exponentially worse, because in this case, the argument is that Trump paid to conceal information that would have harmed the election had it become public. My understanding is that even in law, it would have had to been exclusively for that and for no other consideration, whereas there's plenty of other considerations for which, even if it happened, which I still don't think it did, there's plenty of other considerations that could have legitimized that payment. Hillary Clinton was not paying to hide information that might hurt her campaign. She was paying to fabricate information that would hurt someone else's campaign. It was fake, and they knew it.
It would be laundered through the federal government, weaponized to spy on people,
weaponized
to interfere with. I mean, to such a degree, it may lead to us at risk of World War III. You couldn't have a more consequential, damaging lie than the one that Hillary Clinton helped spread.
The Steele dossier, they funded it, and they knew it was bogus. They then, through their attorney, leaked it to the FBI, for which the attorney, Sussman,
lied to the government about its sourcing and about where it came from, who was funding it, all of it. Just lie upon lie upon lie. And this what they've done is they've taken their crimes and projected onto Trump.
Yeah. And Sussman was acquitted despite the lie being black and white because he charged the campaign for it. The FBI then leaked it to Yahoo News that published it. The FBI then relied on that publication to go get illegal spy warrants on Carter Page to pivot step, whatever they call it, to the Trump campaign. That's what Clinton did. And she was in New York. Alvin Bragg, mum, Soros doesn't want to go after Clinton. Trump, even if everything is true, paid to catch and kill a story that he had 15 reasons to want to suppress above and beyond any election, although it had occurred earlier. And apparently, even by the facts, he said, I don't care about it. And of the 2 of the 3 stories that they caught and killed, one involved the doorman, ended up being false. They denied it, but they paid the guy anyhow. Stormy Daniels, which everyone denied until they no longer denied it. And I forget the third one. Robert, sorry, go for it.
Yeah, there are the 2 other issues I want to highlight. Yeah, we did a deep dive on this on the Duran, so people want to watch that discussion, they can. Also with Thomas Woods on his podcast and with George Galloway earlier today. But the 2 other issues I think worth highlighting because there was some legal controversy about this. One is, could it be a federal campaign finance violation? And I'll explain why I think it cannot. And also there was this suggestion that could be no constitutional basis to say that the indictment couldn't happen against a former president. I'll explain why I think I disagree with that. So on the campaign finance, and this is where what we're highlighting here is the risk a bad interpretation of the law from the Trump case endangers everybody else. So Trump has a bunch of other defenses: statute of limitations, recusal, disqualification, selective prosecution, whether or not it adequately states a crime, whether there's been grand jury misconduct, all of that are specific to Trump. To Cohen, he's an incredulous witness because he's a self-confessed perjurer and fraudster and liar. Who's given conflicting statements at different times. Stormy Daniels given conflicting statements at different times. Her lawyers being connected to extortionists, including Michael Avenatti, who's in federal prison for extortion. Putting all of that aside that are specific to Trump, we're going to highlight here the issues universal risk. The campaign finance laws say that the only thing that so you have direct payments to a campaign. Direct payments campaign, no dispute. That's a funding of a campaign. That has to be disclosed. And there's certain limits that an individual can give. But what happens when somebody spends money that doesn't go directly to the campaign, but they want to call it an indirect contribution? Well, what the law is that if the purpose of that expenditure, that's what the law says, not a purpose, not an purpose, not incidental purpose, not collateral purpose, but not the main purpose, the purpose, exclusive. If the purpose is to help somebody get elected, then it has to be disclosed. Then it stays within the limits. The problem with saying that, let's do 2 issues. One, the indictment alleges Trump wanted this done all the way back at the time it was done, and he simply used Michael Cohen as his conduit. Well, that's not illegal. Trump can donate however much he wants to his own campaign. It doesn't matter. Trump can give as much as he wants. He can spend as much as he wants. That's constitutional. That's what the combination of Buckley, Viva Frei, and Citizens United is about. You have a First Amendment right to spend as much as you want on your own campaign, because the only thing that's considered constitutional is third-party quid pro quo corruption risk. So the idea is a third party is trying to bribe me through campaign donations, so that the Congress can limit the amount of and require the disclosure of, but not if it isn't in that category. The U.S. Supreme Court made this clear repeatedly. So if it's Trump doing it, as the indictment suggests, then it can't be a federal campaign finance violation, period. If, on the other hand, what they're saying is this wasn't done at Trump's behest or behalf, that Cohen did it on his own, and then Trump wanted to reimburse this illegal donation later after the campaign to cover up the fact that it was an illegal donation, the problem there is they have to prove that the purpose for, now there's still an issue, because if Trump's reimbursing it, then Trump's implicitly authorizing he can spend as much as he wants. It's no longer a limited contribution. But putting that aside.
But let me stop you there, because some people said if it came from a Trump company, that defense would no longer be accurate.
Doesn't matter, because none of these are publicly traded companies. These are Trump. He owns them personally. So it doesn't matter how you, that's what Citizens United was all about. That was a corporate entity spending as much money as it wants, clearly to influence the election. And the Supreme Court said, doesn't matter. You can spend as much money as you want to influence an election. You only can't do it if the purpose is to influence an election. And if it's a third-party payment like Citizens United, it has to be in coordination with the campaign. So here, in order to allege, they have timing problems issue, because how is it something he did in 2017 was to influence an election that happened months before? There's that problem, right? So But in the end, if they're going to argue that Michael Cohen's payment to Stormy Daniels was a legal campaign contribution in excess of the limits and not timely disclosed, then the issue is they have to prove that the purpose of the transaction, which means no other purpose could possibly exist. And the reason for that is constitutional. If they can say that anything anybody does, because by the way, the law criminalizes anything of value. This goes all the way back to the debate we had and discussion we had about trying to go after Donald Trump Jr., about that Russian woman who met with him and so forth. And so in order for this to be criminalized, that's the reason why "the" has to be limited. If it's not read in a way that's limited to only apply if it's solely for the purpose of, exclusively for the purpose of influencing an election, then they can come after the rest of us. Say, hey, you did something of value. That influenced an election. You knew it could influence an election. You didn't list it as a donation. It was in excess of $2,200. We're going to call it that. Bam, now you can go to federal prison. Now you can go to state prison. That's why this law has to be interpreted very narrowly. And the problem they have is everybody knows he had 100 reasons that were actually more compelling. He had protecting Trump's brand. He had protecting Trump's relationship with Melania. He had protecting Melania's reputation itself, protecting his family's reputation themselves, protecting Cohen's reputation as the fix-it man. There were a bunch of reasons to do this, independent of influencing the election. And for that reason, it can't be a federal crime, period. And you don't have to take my word for it. The FEC commissioner came out this week and said, this is not a crime. It didn't even violate civil election laws or rules.
Hold on, let me pull that up, because for people who don't, I'll find. Oh, here we go. No, that's not it. And the FEC chairman or whoever it was literally said this was not an FEC crime. This was not a federal crime. That's why we didn't do it. And so, okay,
which the Southern District of New York had already also determined. Now, last but not least, the constitutional risk here that's of universal concern. Some people were saying that there just couldn't be a grounds to say that there's anything in the Constitution that concerns indicting, trying, or sentencing or jailing a former president. They're ignoring the plain language and plain text of the Constitution, because the Constitution specifically and explicitly provides for when you can bar a former president from office, when you can remove him from federal office, when you can, and it also talks about when you can indict him, when you can try him, when you can sentence him, when you can jail him. And what it requires is impeachment by the House of Representatives and conviction by 2/3 of the Senate. And it says if those two things have occurred, then you can remove them. And then it talks about, think about, what is a removed president? He's a former president, isn't he? So they're saying after remove him, you can bar him from all future office, and you can indict him, you can try him, you can sentence him. It's not a coincidence. There's some people out there who, are purporting to represent January 6th defendants, and apparently I see why they're so inadequate at it. When they can't even read the Constitution. They've been lecturing, trying to troll us all week. I won't name them because they want it. They're trying to troll themselves into relevance. It's not my fault. They're idiots. But the plain language of it's not a coincidence that language about indictment, trial, and conviction is in there. It's not a coincidence. It's right now. It comes in for it only applies to former presidents, almost by definition. Now, you can argue it applies to current presidents by implication. But it explicitly applies to former presidents. And it says you have to, and there's practical reason for this. We don't want presidents when they're out of office or while they're in office worried about what happens when they're out of office, that they could be subject to criminal prosecutions by some random state, local, county prosecutor, of which we have thousands in this country. And instead, they were like, no, that's always got to go through the House. That's always got to go through the Senate. Now, I believe selective prosecution principles and other principles also prohibit constitutionally indicting your leading political opponent. I think there's grounds to stay those proceedings until the outcome of an election. But putting that aside, my view is a former president, once a president, you are protected by the impeachment clause. It's the only way you can be indicted. And for people that say, oh, there has to be a means to, what if someone is a serial killer? What if that's what the impeachment clause takes care of? If it's so obvious this person is a imminently dangerous criminal, the elected representatives of the House and the Senate and 2/3 of the Senate will then convict him. Trump has never been convicted. He's been twice acquitted. This information about Stormy Daniels and the finance issues was known at the time of both impeachments that were brought. They were not even considered sufficient by a Democratic House to even include as grounds to impeach him, least of all grounds to impeach, convict, so that he could be indicted on them. That's why I think constitutionally, the president has a separate, independent constitutional grounds that I think is important for all of us moving forward, because if the president is subject to the whim of a future prosecutor, then basically what happens is we give all the power to a local prosecutor. Some local prosecutor can say, I'm going to imprison you unless you do what I say. And maybe I'll wait for you to be out of office, maybe not, but that creates all kinds of problems. And it's not a coincidence our Constitution anticipated this risk and put the language in there that impeachment and conviction must precede indictment, trial, or conviction.
It's a very compelling argument you raised there, Robert. And I had not actually even thought about that such a serious crime, everybody knew about this alleged hush money payment, and never brought it up for the grounds of an impeachment. Some people in the chat, Robert, let me see here. Jennifer, $5 rant, says, how can Trump win another lawsuit against Stormy Daniels and be charged? Isn't this election interference by Bragg? Hope this boomerangs back to the Soros puppet. Yeah, it's how is this not overt election interference? And how is it not election interference?
It's why, in my view, it's what the Constitution anticipates by having this prohibition, right? We're not going to let local prosecutors interfere with an election or interfere with the executive branch, the elected head of the executive branch, by having this power. We're not going to give it to them. They only have this power once Congress, the elected representatives at the national level in the federal office, have more than 2/3 of them in the Senate and a majority in the House, have impeached him and convicted him on. And that's why it's a critical constitutional buffer against the overt, open political weaponization of this process. And I think it's critical that it be at least raised in these proceedings, because otherwise we set a very perilous precedent.